It's March 7th, 2026, and this is the Court Gallery. Welcome, ladies and gentlemen. It's going to be a long Saturday full of crazy court cases. We're starting things off in Thurston County with a personal protection order case where the family just needs to leave well enough alone. Then we're moving on to Texas with Judge West, who has a repeat theft offender who just can't get it through her head what she needs to stop doing. And then we're moving back to Michigan with Judge Middleton and a young man with some communication issues and a very interesting and moving court case. And finally, we're going to see Judge DeSanto, where we're going to hear about a very crazy landlord-tenant matter with a heating issue, and it all starts right now.
So we'll turn next to Tim and Trisha Coffin. Yeah, come on. And Stacy Miller. Okay. So I have read the petition. I've read the petition for both this case as well as the one with Mr. Gill. My understanding is some of the events overlap. Is that, you look at me like maybe not.
Speak up for him.
Oh, I'm sorry.
Yeah,
you need me to speak up? Oh, I'm sorry.
More.
Okay.
I'm sorry.
No problem. So what I was saying was I have reviewed the petition in this case against Stacy Miller. And just so that it's helpful for folks, I've also reviewed all of the documents in the petitioner's petition against Jax Carngill, we're not having that hearing today, but it sounds like some of the events may have overlapped. And so I'm just so the parties are aware, I have read that as well. I think most of the documentation from that incident is in the petition with respect to Mr. Gill. But I've read that as well. That's not part of this petition though, but to the extent it's referenced in this petition, I've read that as well. So I know you've all been here all morning, so I'm not going to go over the definitions and all of that again. If we have to kind of bring us back to those definitions, I'll do that. But again, all the ground rules remain the same. It's a bit easier since I've got the Coffins in court and Ms. Miller, you're on Zoom. But again, comments towards me and everyone will have their turn to speak. And as you just saw, I'll ask a lot of follow-up questions. So we will get started here. I will put Tim and Trisha. And is it Coffin? Is that how I
Caffeine.
Caffeine? All right. Sorry about that. Caffeine. All right. I'll put the two of you under oath. You can both raise your right hands. Do you swear affirm the testimony you're about to provide is the truth, the whole truth?
Yes.
Okay. Go ahead. Whoever would like to speak first. Again, as I told the other parties, I've read everything, so no need to walk me through everything in the petition, but if you'd like to summarize it, please go ahead.
I guess I'll start. So there was an altercation at the Miller's residence there. Obviously, is dictated in the reports there. I have petitioned for a protection order on both parties due to that altercation that you have the information on there. Wife and I went out for Valentine's dinner like we always do. Heading back, we were going to stop by and see our grandkids there. Reached out to who we thought had the children at the time. Did not. That was Mr. Miller there. He let me know that the children were at the house there. Go ahead and feel free to, like we always would, just swing by. there. At the time of the visit there, do like I always do, knock on the door, listen for the response behind the door, open up the door. Needless to say, ended up being an altercation there, which we have multiple files going on with your court right now on that. But with the assault that was done in the house and outside the house there, is what caused us to put the protection orders in place there on that. Also, the aggressiveness of the situation with Mr. Gill while I was on the phone with 911 at the same time there on dispatch. The aggressiveness chases down the driveway there while officers were pulling in. At the same time, the aggression from Miss Miller towards our vehicle while we were sitting in our vehicle with an officer right there present. I do have that police report, and I believe I provided that to you there, stipulating that. I have left multiple phone calls for that particular officer and the supervisor to give us a call back, but we haven't heard back from them yet on that. Over the last couple of years, the aggressiveness from Miss Miller towards my wife has gotten pretty verbal on that aspects there. So there hasn't been much contact between the two of them there. But Miss Miller and I have kept a reasonable relationship because of our her kids, my grandkids. They mean the world to me. So I've always tried to keep that open line there on that level. There's been multiple conversations and threats and things like that that would keep the kids from coming and spending time at our house there on that. Used as more of a pawn than allowing the children to spend time with their grandparents there. Right now, since we've started this particular situation, we have had vandalism towards my wife's vehicle there, which is in the police report that Chehalis Police Department has taken there, with the pictures and the documentation of the vehicle that was seen on the video cameras at the residence and in the police report that's stated there. I feel right now the protection order should stay in place there on that, because we are worried with the fact that, you know, the sudden vandalism just to her particular vehicle there at our residence there is made it very alarming, and we ended up having to notify our neighbors of the situation there. Everybody on our street has now got cameras up there. We also have installed more around our property to make sure that we're safe at all times. There has been a lot of aggression that has come forth.
So if I could stop you, so you've mentioned a couple of times a lot of aggression, multiple instances, things like that. So apart from the Valentine's Day incident at the home, do either of you have examples, dates, things like that, as far as what that sort of aggressive behavior is you're referencing?
It's been phone call conversations between myself and Miss Miller that have gotten very verbal over the phone there. Also multiple conversations between Miss Miller and my wife, Trisha Miller, or Trisha Cuffing, and those have gotten pretty heated there on
And
those.
in those conversations, have there been, again, I know you all were here earlier, express direction to Miss Miller to not contact you anymore?
No, we haven't done that. Miss Miller's been, her and my wife have kind of split that ways. That way they don't really contact each other at all there. Myself and Miss Miller keep in contact for the kids' sake there, going to birthday parties, family functions, things like that. On that note, Miss Miller just, with the tension between her and my wife, she doesn't come over to our house. Normally it's the father, Mr. Miller, that brings the children over to the house.
One phrase in the petition was that Miss Miller has threatened to cause bodily harm multiple times. Are you able to go into any more detail about those?
Those were conversations that she and my wife had on multiple occasions there.
Okay. So Trish,
She'll have to speak on that.
yeah, would you like to speak about those?
Specific dates. This has been kind of an ongoing thing between me and Miss Miller throughout the years. Anytime she gets upset with me, the threats would come. I'm an immigrant, so she would threaten to have me deported, or, it would become verbally abusive over the phone, and had threatened me a few times over the years.
When you say threaten, what do you mean?
That she was going to kick my ass if she ever saw me.
And you don't have to give me dates and times and things like that. Are you able to give me a kind of a rough estimate of the timeline we're talking about? This has been the last few weeks.
No.
I know you said over the course of years,
Yeah.
but can you think of some of the more recent times where maybe those interactions have taken place?
Well, the most recent was Valentine's Day, when she got out of her car and came at me, and my husband asked me to roll the window up. I had my window down because I had been talking with an officer. When he saw her go to get out of the car, he said, "Roll your window up." And sure enough, as I was rolling my window up, she punched the driver's side window. So had I not listened, she would have gotten me.
Were you with the driver?
Yes.
And so I'm clear on what you're asking for, because it sounds like, Mr. Coffeen, are you wanting there to be any continued communication between yourself and Miss Miller? None at all. So as far as discussions about your grandkids, her children, anything like that? Nothing.
It hurts.
Yeah. Okay.
It hurts having the distance with my grandkids.
Mhm.
But I think as far as of right now, I don't think that needs to be any communication between Miss Miller, myself, or my wife at all. As hard as that is to say, yeah, I think it's in best interest for us. I believe it's in best interest of Miss Miller as well. Probably in best interest of my grandbabies.
I have, I believe, one more question for the two of you, and then I'll turn it over to you, Ms. Miller. Mr. Coffeen, you referenced a vehicle being vandalized. I believe it's been referenced in your petition too. I'm trying to pull it up. Let's see. I don't have the police reports from Chehalis, as you said.
Yes.
If it was filed in Chehalis, we don't have access of that necessarily. Here it is. So I've got your declaration though. When you indicated this was It's February 17th. Sounds like your Forerunner was vandalized. And I understand you're saying it was the only car on the street that appeared to have been vandalized. Do you have any, and I'm not asking, this isn't a criminal investigation.
No, they
I'm just
have
curious, do you
pictures
have
as
any, not of the car, as far as your conclusion that it was Miss Miller who did it?
Yes, what I submitted to the court here. Also, I submitted to the sheriff's department down. Actually, I believe I just did it to the sheriff's department. He wanted me to bring them in there. It shows the pictures of the vehicle on the camera. It also shows the vehicle parked in Mr. Gill's driveway as well.
Maybe I missed this, but
Yeah, there's multiple pictures. I might have duplicates too if you need them.
is it the pictures? So we've got two pictures of looks like a walkway.
The white car that's in the background. Or which pictures? I'm not sure which ones you're referring to.
These might be pictures that were sent by Miss Miller. If you've got them there, I can.
I was going to say, I'm sure I've got duplicates of everything. My other concern, Your Honor, is that there seems to be a way that Miss Miller and Mr. Gill are able to reach information. We have an inside source that well, they've already been submitted these pictures. I had 2 copies. Shayla's has one, and then your sheriff's department got it as well. Or not the sheriff's department, your clerk out here right out in front of building or office 2, courtroom 2. Yeah, you guys have both. You have a copy and Shayla's has a copy. But between the vandalism there and the aspects that the vehicle was punched right in front of officer there at the scene there, malicious mischief definitely comes into play there.
Yeah. Said that. Okay. All right. Okay. But I have your declaration about the car and everything like that. Okay. So we've addressed the car, the incident on Valentine's Day, some of the more kind of ongoing conversations between the two of you and Miss Miller. Before I turn it over to Miss Miller, anything else you'd like to let me know? I'll as you saw before, I'll turn it back to you likely at the end with some follow-up questions as well. But anything for now before I turn it over? Okay. Okay, so Ms. Miller, if you could please raise your right hand. All right. Do you swear from the testimony you're about to provide is the truth and the whole truth?
I do.
Okay, so go ahead. You'll have a chance to respond.
So I don't want to go too much into the weeds considering you've been able to read everything, but on the night of Valentine's Day, I was supposed to be taking my son to my soon-to-be ex-husband's house because we no longer reside together and haven't for months. At the time that I left, I received a phone call from my oldest daughter screaming and crying, saying that her grandfather was fighting with Mr. Gill in my living room and that her papa had come in, walked through the door, did not get the door opened for him. He did not knock. He walked in. Mr. Gill was standing in the kitchen there was 5 kids here that day. Rightfully so, Mr. Gill stopped Tim and asked him who he was. Tim refused to say who he was, and this was verified by all of the children that were in the home. And Tim proceeded to proceed with aggression. Mr. Gill did what he thought he was right and tried to get Tim out of the house. And I guess the altercation happened with them. Mind you, I am not home. I'm just on the Ring camera and on the phone. I opened up my Ring camera to Mr. Coffeen and Mrs. Coffeen standing in my front walkway, them screaming at Mr. Gill Gil's telling them, you need to leave, get off the property. I was screaming through the ring camera for them to leave because at this point, I don't know what's going on, why there's someone at my house when I didn't tell anybody they could come in. And then you just walked into my home and put my children at risk. So he was told he needed to leave by both of us. In the midst of all of it, there was, as you can see in the court record, that there was a gun in the home. It is not my gun. I don't own guns. I don't like guns. Everyone who knows me knows I don't do guns. Rightfully so, Mr. Gill had a right to protect himself and the children, which is what he did. When I got here, Tim and Trish were sitting up within their vehicle, kind of like at the entranceway into our cul-de-sac. When I pulled up, I put my vehicle in park, and I did. I started yelling at them, asking them, what are you doing? Why are you fighting in my house? What is going on? Trish proceeded at that point to open up her vehicle door, get out of the vehicle, standing halfway in, halfway out, calling me a whore and a home wrecker and all this other stuff. So there was a verbal altercation there with both of us. As she came towards me, I came closer at her. There was contact with the window. No, it was not a fist. It was an open hand. At this point, the officer that in one of the reports even stated he came in up to the scene, noticed that we were visually arguing with each other. He watched Tim get out of the vehicle and was instructed to get back into the vehicle. So they were not in there the entire time, as stated. There was absolutely verbal disagreement and aggression between all three of us. I was upset my kids were placed in harm's way, which is, I feel, is highly unacceptable. But then you also came into my home where you're not invited into and tried to take my children. And that was the basis of all of it. When
Ms.
you
Miller?
go back, yeah.
No, no. All right. So
Go ahead.
we'll use you, right? You're talking to me, right?
Mhm.
So,
Yeah.
so when you're saying you came into my home and things like that, right? You're
No, I
telling
meant
me
like
what
when
happened.
he came into my home.
Right. So keep it like that. Keep it in kind of in a narrative form, not,
Okay.
not talk. All right. Go
Yeah.
ahead.
So he had come into my home after speaking with the officers and going through the reports and speaking with my children's father. It was determined that Tim took it upon himself to show up at my home. And there's conflicting reports with all three of the statements from the officers on why he was here to begin with. Come to find out, my kids' father is the one who asked him to come inside and grab the kids, is what's on record. However, the kids' father is now denying that and saying that Tim took it upon himself to enter my home. So with the conflicting information of everything that went on that night, I messaged Tim on the 17th, so the night he's claiming there was vandalism, and let him know, because my children were placed in harm's way, I think it's best right now that my children do not go around them. I'm a mom, I'm a nurse, my kids come first. That's all there is to that. And because of the fact that he loves his children, his grandchildren so much, then the whole thing with the retaliation of vandalism occurred. So in the records, you can see I uploaded the day that I was at work that night that he claims the vandalism occurred, when I left my home, when I returned home the next morning. I worked 12-hour shifts, as well as my time clock showing I was at work. But I also want to state too that occurred apparently in Lewis County, not Thurston. So I'm not too sure why it's in this petition, because it's not something you guys would necessarily have jurisdiction over. But that's kind of where that went. Ever since then, I have not talked to him. I never even sent that message directly to him. I sent it to my children's father because they're in contact. I didn't want to have any contact with him. Still don't. Still have no intent to go around him or his wife. He is correct in saying there has been verbal altercations between her and I, but never in a million years would I threaten harm on my family, regardless at the end of the day of how I feel. So I feel like all of this stemmed out of retaliation after the report came out saying that Jaskarn did what he should have and acted in self-defense. And because of that, the case was closed. And as Tim's referring to us getting records, it's all public. And I don't think he quite understands that. Everything you upload is public. You can see it on the civil courts documents. So it's very easy to get that information. That's the only reason I knew I had a court date today, because he failed to have me served.
Thank you. All right, Ms. Miller, thank you. All right. So the pictures that are uploaded for you looks like from February 17th and 18th, one leaving, one coming. So those are of you, you're saying, coming and going from work?
Correct. I leave for work at 6 p.m. and I don't get home until about 8:30 the next morning because I usually take my kids to school. But that day, my son had an appointment in Seattle. So I picked them up, came home to get them ready, and then turned around and had to leave again.
And where do you live?
I live in rural Thurston County. So Thurston County sheriffs are the ones that had responded. And that's who I had to contact to figure out where my paperwork was because I hadn't been served. And I was notified that Tim intentionally, this was from Thurston County Sheriffs, Tim, I guess, intentionally took my documents to Olympia Police Department in hopes that they would serve me because my job is in Olympia Department, like their county. But I talked to OPD as well, who stated they have zero jurisdiction and I would not be being served because the proper documentation is not there.
And the incident here, okay, all right, thank you.
Yeah.
All right. We don't have any pictures of the car. So it sounds like you brought something. Is it pictures of the car having been vandalized?
There's quite a few variations here in this story that she just presented. First off, we were told to take the paperwork to the Olympia Police Department, so they did have that.
Okay, so we're not going to deal with service.
But,
I know. But listen, we're not going the issues with service and all of that. I'm not going to get into. She has actual notice. She's here, so we're not going to go down that path.
Okay.
So we're not going to go down there. Because we don't have access to anything in Chehalis. So what is it as far as the car being vandalized? The
car that she refers to is not her car, so all of that is irrelevant.
Right. No, but you said
the car that was vandalized was my wife's vehicle. It was not her car. It was Mr. Gill's car, and those are the pictures that were brought into this clerk here, and also put into the Chehalis Police Department there when we made the report, because we caught him on the camera.
Okay.
It was not Miss Miller's car.
So
Mr. Gill's car. And that's why it strictly shows in the pictures that car with him in the picture.
So is it the SUV or the Toyota 4Runner that's alleged to have been
the 4Runner?
Okay. And Miss Miller, what are you saying? That's
no, I'm just saying, like, I haven't seen photos of this alleged vehicle. My kids' father was told it was silly string on the vehicle. So I don't know what the vehicle looks like or what's going on. And I would like to know, I don't know if it's possible to know where this vehicle was even parked because Mr. Gill doesn't live around here, nor does he drive a white vehicle.
Right. But it's okay.
So I'm not too sure why this is in my thing.
Well, I think what the Coffeens are claiming is that their vehicle, this 4Runner that is theirs, was vandalized, and they're claiming that you vandalized it.
Correct.
No,
is that not right?
Not her.
She did it, but somebody, she sent someone.
Okay, and what evidence do you have of that?
The car that was shown on the camera that we took was also the same car that because originally serving Mr. Gill there, the Puyallup Police Department is the ones that sent me up to that address there. Find out if this vehicle is there, drive 3 blocks away, call them so they could serve him. That was the reason I went to that address. I learned on social media that particular car that was on my video camera there was the exact same vehicle that he's showing in the photos that everybody has there with him in the picture right next to the same car.
While it's vandalized, like around the time it was.
So we have the first photo that has the vehicle there. We have the second picture that shows the vandalism that was done. The third picture is the one that shows the exact same car in Mr. Gill's driveway with him standing in the picture with his daughter.
Okay, but it
had nothing to do with Miss Miller whatsoever.
Okay, all right.
As far as her car,
all right.
I can't, because of the fact that they purposely turned the lights off going down the road right after they did it. There was the only other reason we couldn't see who the driver was.
Okay. All right. Okay, so I'm going to try to narrow this down a bit. All right, so first of all, with respect to the evening of the February 14th, all right. Sorry, I'm flipping back and forth between some of the notes I took for the
there's a lot. Sorry.
Gill matter. It's okay. All right.
I received a concussion and now I have hearing loss
Right. No, I understand.
during all this.
Yeah,
as
and
well.
that's all in the Gill packet.
Yeah.
All right. So, with respect to so Tim Coffeen and Miss Miller. All right. So the basis of asking for a protection order between the two of you, it sounds like, are the incident on the 14th February, and it sounds like you've had conversations over the years that have been heated. You've never been told not to contact each other, but those sort of escalating arguments on the phone, what happened on February 14th, there's allegations about how a car got vandalized. Are those kind of the main arguments for wanting that protection order?
Yes, and the fact that she has told multiple people that she wishes I was dead will be something I will always have to remember on that case there. For
And where did that come from?
right out of her mouth.
Okay.
Over the phone.
But how did you learn about that? That she told you
told
that,
me.
that she wishes you were dead?
There while I was fighting cancer.
Okay.
So that there, allowing and thinking that it's okay that, you know, she wasn't there, so she did not witness what happened there on the night of the 14th there.
Right, and we're not going to get into the
I don't
fight
want to get
between
into
the two
all
of
that.
you.
So
Right.
I'm just saying that
Right.
there was a lot of discrepancies there,
Right.
as far as that goes, and she should know.
Okay.
But you know, it is.
And then
He said, she said. So
okay, all right. Thank you, Mr. Coffeen. And then with respect to Miss Miller and Trisha Coffeen, it sounds like the basis there is a bit of a longer period of conversations in which, and this is where I might turn back to you, Miss Miller. You heard Trisha Coffeen there say that there's been some threats over the years where there's been, you know, threats of bodily harm, threatens to kick her ass. I think I heard reference to, you know, deportation, things of that nature. I'll let you respond to that specifically because, you know, as we were all here earlier, you know, one thing that I have to suss out is whether there's some sort of pattern of behavior, you know, over a course of time. And so that one with respect to Trisha Coffeen, I wanted to know a little bit more about. So you heard her side of things. I'll let you respond to that. So talk about your conversations with her over the years.
So over the years, initially, her and I did start off with a rocky relationship. She was someone that regardless of how they met online, there was a big altercation with our family as far as verbal goes between myself, her, our grandmother, which is my dad's mother, and my dad, just based on allegations that she was coming here for a green card and this and that. So that's the part that she's referring to. As far as deportation goes, to my knowledge, she was here legally and has a green card and has since my sister also came to the States. So I don't know where she's getting any of the whole deportation aspect of anything. Our relationship over the years, it has been rocky. There's times where we do get along and we get along great. And we're your mother-daughter relationship and she's great with my kids. And then there's other times where she's not. And we're arguing with each other about how my dad feels he can't see the kids. And that's where a lot of that animosity stems from is you have to respect the parents of the children. Otherwise, I'm not giving you access to my children. And he may call that upon or whatever it may be. But my kids' mental health comes first. So I'm kind of surprised to say that they said that I would ever threaten bodily harm or even killing somebody at that point or wishing they were dead. Those are my kids as grandparents at the end of the day. And as long as you respect me, you see my kids. But I'm not going to threaten harm over you.
So you're denying that you've threatened to cause
I am
harm.
absolutely 100%.
And then Miss Caffeine, in addition to your allegations of threats of bodily harm over the phone, has there been anything in person that would indicate to you that she was serious about following? What?
Oh, we've gotten in heated face to face, like she came right in my face. Did she make contact? No.
When you say she got in your face, were there's also you're saying threats of bodily harm in those instances?
Yes. Okay. This has been ongoing, like I said, off and on for years. And what she said is correct. We had a great relationship. But the lack of respect and her wishing her father's death, she has no family left. Everybody, because of her aggressive behavior, has left her in the dust. Unfortunate.
All right, so here's to sort of let people know where I'm at. The element here that I'm having a hard time finding, and I'll give the petitioners a chance to respond. Here is whether or not Miss Miller has had clear notice that you don't want contact with her anymore, because it is not necessarily unlawful harassment to say very hurtful things. Threatening bodily harm is different. And if someone is in reasonable fear of their safety because of things that are being said to them, that's different. So I'm going to put that aside for a second. Saying very hurtful things, telling you that, and for your benefit, I'm pointing at your father, she wishes you were dead at a time when you may have it sounds like you had cancer. Like those types of things, if said, are extremely hurtful, obviously. It rises to the level of unlawful conduct that requires the courts to get involved. When someone is making comments like that, knowing it's causing substantial emotional distress, and they, after being told to stop, continue to do so. Right? That's what we're looking for as far as harassment because of communication, not those initial things that are really hurtful, and then you go to court and you get an order asking them to stop doing that. The court order comes after they've been told to stop and they keep doing it. That's when the courts become involved. And so the piece that I'm sort of missing here is when Miss Miller was sort of on notice from you that, and I say you, I say both of you, but again, I'm kind of putting the threats of bodily harm to the side for a moment. When she was giving notice from you that you didn't want contact with her anymore, especially because it sounds like while things have been very rocky, to say the least, there's been some communication for the sake of the kids and the grandkids, at least, to see each other. But at this point, especially after the Valentine's Day incident, it sounds like the situation may have changed where folks don't want contact with each other anymore. And so what I think I'm hearing is, by and large, at this point, everyone, sounds like, is sort of in agreement that they don't want to talk to each other anymore and they don't want any further communication. And at this point, I'm hearing some pretty clear communication to me that communication is no longer welcome. I don't know if I heard that before, though, moving up to this point, but I'll let you, it's your petition. So I'll let you respond to that. If you can point to, some interaction where, you let her know this is no longer appropriate. I feel that this is harassment, emotional distress, and I don't want to hear from you anymore.
I did.
Okay, go ahead.
I had a conversation in my kitchen when I'd put my foot down a few months back. I had enough. The verbal abuse that I was getting, I'm pulling your grandkids away from you. You're not going to ever see your grandkids again. After I got my oldest granddaughter into, actually, my wife actually got her into horseback riding lessons there. We ended up getting in a major argument on the phone, and because of her aggressive nature, she always has to get the last word in. She doesn't talk reasonable like normal people there. On that, I told her I was done. Do not contact me again. I blocked her on social media. I blocked her phone number. there that I'm done. I'm putting my foot down because my wife had been standing up for the way she had talked to me and treated me over for a long period of time, causing issues between us because I would always stand up for her there, which caused issues here. And I finally, at that point, I was like, I'm done. I'm enough there. And as far as showing extra history there, now it doesn't pertain to this case, but giving you a little bit of a lowdown on the background aspect there is Miss Miller has had a deferment charge on a assault with her next door neighbor there at her residence. So she does have an issue with anger management aspects there. I think a lot of it is due to not staying on her medications there. I've always felt that when she's on it, she's good. She's stable. She's just like you and I talking. But when she's not, it's just not good there. And it causes issues with everybody. That's why right now, nobody in the family on my side wants anything to do, because we never know what part of Miss Miller we're going to see or get there. And unfortunately, in your situation is that now you have to decide how to deal with it, because now we have aggression going on. And now I have to deal with it because now I don't get to see my grandkids.
Right. And so, well, and thank you for that extra context. And the thing that I keep going back to for February 14th is, not separate from the incident between you and Mr. Gill. Even if there was, expression to Miss Miller that you didn't want to see them talk to her anymore, that you were, like you said, I'm done. And you may have, after talking to Mr. Miller, felt that you had a right to go to the house. And I'm not weighing in. Yeah. And I'm not weighing into that one way or the other. But what I'm saying is, clearly, though, it was in your mind, and it may have been reasonable, felt that you could still go to where Miss Miller lived, right, to see the kids. So and I'm bringing that up to say that, what that tells me is there may have been a conversation where, you say, I'm done, this isn't all of that. But following up, at least on Valentine's Day, you went to her house. And so what that communicates to me is that there may not have been a clear break, if you're at her house with her kids, in your mind, again, I'm not saying reasonable or unreasonable, just that whether or not you felt that there was a clear break where you wanted nothing to do with her and you didn't want to see her anymore. That might not have been as clear as evidenced by the fact that you were in her home with her kids and she may have been there, right? You're looking confused. So I bring that up to say what I'm looking for is evidence that Miss Miller was on very clear notice that you didn't want anything to do with her anymore. And what I'm saying is, it sounds like you said a couple of months ago, at least, you had a conversation where you said, I don't want anything to do with you. Mm-hmm. But then what I'm also looking at is on February 14th, you were at her house, right?
At her and her husband, my son-in-law's house.
But her house too, right? But her house too,
right?
And so what that tells me is that may not have been as clean a break, as what we're talking about here, right? Because she could have been there. They were her kids, right? And so to me, that's evidence that there may not have been a clear expression of, I don't want communication with you anymore, right? Because then you were at her house on February 14th. So that's what I'm saying as far as that goes.
Okay.
Yeah. So I think where I'm coming to, I think, is, there's a date at which it's become very clear that the two of you don't want any more communication with her, right? And that's that Valentine's Day incident that involved Mr. Gill, but also Miss Miller. And looking through the record, it seems to me like that's kind of this flashpoint in the relationship where it is now clear that the two of you don't want any communication with her, even regarding the kids, anything like that. And it seems like Miss Miller at this point is on very clear notice about that. I don't know if that clarity came through up until that Valentine's Day incident, though. Enough for the courts to get involved and issue court orders, if that makes sense. But the carve out I want to return to, though, is specifically with regard to Tricia Coffeen and Stacy Miller, because that kind of clear notice, that's always still a factor. If somebody is threatening bodily injury to somebody, it's not like you then have to tell them to stop and wait for them to do it again, right, to go to court. So that is a different situation. So I'm not talking, so I want to return to that here. And I've got your testimony here and I've got her testimony, and you're saying it happened, and I'm sorry, Ms. Colleen is saying it happened, and Ms. Miller saying that it didn't happen. And so, you know, that when it's that situation, you know, you've got what's called the burden of proof, which I went through earlier, which is it has to be more likely than not that it happened. And so it's sort of when it's both sides are telling me completely opposite things, the court needs something else to get over that burden to say, yes, this happened. And so now the courts can get involved. Is there anything you can show me that, again, not proof beyond a reasonable doubt, because this isn't a crime, but more likely than not that there were threats of bodily harm?
Well, I can show you the police report from the officer that was wearing body cam.
Okay, and this is what's in the...
To what she stated, that I was out of my vehicle. Not true. I was in my vehicle, had been the whole time. The only time I got out of my car that night was when I had to get Mr. Gill away from my husband before he killed him.
What I'm looking at, and Ms. Miller, have you seen the police report from the February?
I have. I've read all of them. Mm-hmm.
All right, so that's just, I'm going to take a look at that again now.
Yep.
So I have the police report in the Gill file ends on page 2, and it's clearly not finished. And then it goes to a series of pictures.
Should be looking at ID number, that's his Officer Deputy Haisung report that I submitted.
Yes.
On the bottom part, it tells you the incident at the Forerunner.
Yeah.
There, where she approached the Forerunner and punched the window.
Yeah, so here, yes. So I've got that in front of me. So it's, let's see. After getting the male detained, I aired that we had another disturbance and request more units. I ran down the road towards the white Forerunner and another white SUV. I believe the Coffeens are in the Forerunner, Miller's in the SUV. I observed a female get out of the white SUV and walk up to the Forerunner while screaming and hitting the window. I observed Timothy get out of the Forerunner, began yelling at the female of the white SUV. I ordered Timothy to get back into his vehicle. I made contact with the female. The female stated that Timothy in the Forerunner is her father, and then it kind of goes into talking about what happened. Right. Yeah. Okay. Yeah. All right. So yes. Go ahead.
Had I not told her to roll the window up, she would have hit her right in front of Officer Haisung. I mean, right in front of him.
Yeah. So, right. I understand. What I also understand though about this police report is, this seems to have been an exceptionally volatile situation where there's a lot of yelling and obviously it looks like you were bleeding. I've looked at those pictures and, so I'm also sort of cognizant of the environment in which this happened. And it sounds like at least according to the police report, Timothy's out of the car, Stacy's out of the car, they're screaming at each other, Stacy's hitting the window of the car. And it sounds like what I'm looking at for here is this being a part of a pattern of threats of physical violence specifically to Trisha. So that's what I'm looking for here. And so it sounds like the part of the evidence you're providing here that this has been there's kind of been ongoing threats to Trisha specifically is kind of what happened here on Valentine's Day. All right, so I understand what you're saying here. All right, so I'll give everyone kind of the last words here before I kind of make my ruling. Ms. Miller, I haven't turned to you for a while, so I'll let you kind of make some final comments.
I don't really have any other final comments other than you're correct in saying I don't want any contact with either one of them. And they can feel how they feel about that. The only thing I worry about is my children. and their mental health, and that's what's going to come first. And that means keeping them away from people who put them in harm's way.
All right. And Tim and Trisha, go ahead.
Yeah, as far as the kids being out of harm's way, she never had a problem dropping them off, leaving them for days. So that I'm not buying. But I have, since this, I have cut Stacy out of my life probably 3 years. I've stayed away from her. Anytime I've picked the kids up, I sit out in my car. I don't even go to the door. Had no use. I have since had to add extra cameras around my house so I feel safe. I'm looking behind my back because I don't trust her. She's unstable and will blow a fuse quick. And literally it's been home and work. That's my life. I want to know that when I go out in public, I have some sort of protection.
Anything from you, Tim?
To put, for her to sit there and say that I would ever let anything come in the way with those kids is mind-blowing. Those kids there, I've raised those kids since they were babies. When she was working, her husband was working. I was the one that helped them learn to walk, learn their ABCs, went to school functions, picked them up at school, took them to different things, got them into sports, got them into different things there. There was nothing that I would ever allow to come in the distance. You ask any one of those three kids, even the 3-year-old, I've always told him, Papa will never let anything happen to you. For her to allow somebody to come in.
I'm going to just stop you just because I understand that is a very emotionally charged subject. And it's hard to separate what's going on here with that. I understand that. Specifically, what I'm looking for is, why do you feel a protection order protecting you from Miss Miller is necessary here? That's what I'm looking for.
Because for 2 reasons. One, the company that she keeps is not safe for me. As you've seen the pictures, is not safe for me.
But that's against Mr.
Okay?
Gill. What about her?
Her, I don't know what she's going to do at this point. She has so far went to the right that I don't even know my own daughter anymore. I can't trust what she says, what she might do, what she might not do. I fear for the safety of her kids, my grandkids, on a day-to-day basis. I know she loves them dearly. I do. But I fear for what they go through.
But again, I understand what you're saying. I understand what you're saying. So I think the last question I have is, I really want to come back to something that, Trisha, you're saying that you feel that your safety is in jeopardy. And so I really want to hone in and make sure I'm not missing anything. I've got the police report from February 14th, right? I think I understand what the allegations are. I understand it's not clear exactly, but I understand what's being alleged here. And I understand that the two of you have had some really heated conversations where you're saying that she has, threatened to cause you physical harm.
Yes.
Are those the two things that kind of are resulting in you putting up cameras and looking behind your shoulder and asking for a protection order? Is that the crux of it?
Right.
Yeah. Okay.
And I've since installed the dash cam in my Forerunner as well that records 24/7.
Thank you. All right. There's a few documents in the court file I'm going to just review, take a few minutes here. So to the extent I'm kind of quiet and read around, I'm going through the petition again and reviewing some documents here. So just everyone's patience here is appreciated. All right. Thank you for everyone's patience. I understand the volatility of the situation. So I wanted to make sure, I've read everything and fully understand it as best as I can. And, at this point, I'm going to deny the orders. And I want to explain why. I don't feel that there's enough in the record for the courts to get involved at this point. With respect to, Tim cuffing, I think that, I think with everyone here, it sounds like going forward, this Valentine's Day incident, I think was clear communication to everyone that contact is no longer wanted, Ms. Miller, you're the respondent here. So, this is mostly directed to you, that, the issue is notice that somebody doesn't want contact with someone else. It seems pretty clear with them having come to court and gone through all of this that they don't want contact from you anymore. I understand there may have been conversations in the past where, Tim, it sounds like you've told her as such. Again, the thing I'm struggling with is that the Valentine's Day incident happened at her home. And so that tells me that it may just not have been that clean of a break between the two of you, at least up to that point, right? Now there has been. And so, going forward, there might be incidences where the courts can get involved if there's continued contact, because at this point, I think that's very clear. Tricia, it sounds like what you're telling me, it's a much closer call, to be honest. Where I'm coming at is, you're telling me that there's been, verbal threats, over the years. And as evidence of that, this police report from Valentine's Day. And the thing that I'm struggling with there a little bit is, again, I think the location of the incident matters in my mind. The fact that it occurred at Miss Miller's home. I'm not saying you didn't have permission. I'm not saying you didn't have permission to be there. What I'm saying is arguments by you guys that that you felt in fear of your safety around her. That's going up against the fact that it sounds like you went to her house to see the grandkids where she lived. Again, thinking you may have thought you had permission. I'm not saying you didn't. But what I'm saying is that's relevant to me in that if you're going to her house to see the grandkids, that kind of militates against thinking that you're in fear of your safety such that a protection order is required. And so, that's why that Valentine's Day incident and its location has such relevance to me, because by you being at her house, that tells me that there may have been a lot of volatility in your relationship. But you did go to her home. And so that tells me that it wasn't maybe yet at the point where contact between the two of you would result in a protection order. I think now that's obviously changed, right? Police got involved. You guys have filed for a protection order. Like, that situation has now changed. But it's hard for me to get around the fact that less than a month ago you were at her house seeing the kids. And so that's, to me, the most salient point here, and the reason why the orders are being denied. Because up until this point, I'm not seeing a basis for issuing the order on the grounds that contact was clearly communicated. It was clearly communicated. You didn't want contact with her, and you felt in fear of your safety to be around her. Just being at her home on February 14th, I think, just militates against that. So that's the reason for the denial today. But again, obviously the situation has now changed, and if there's continuing contact going forward, and this is different than we have another hearing in 2 weeks for Mr. Gill. I understand it's a different situation, but at least with respect to Ms. Miller, I don't see enough at this point to believe more likely than not that there's a grounds for the courts getting involved at this point. So I'm going to deny the order. I understand that's not the outcome
this is
like.
This is the problem with the court system here.
It's okay.
It really is, because it takes somebody dying in Thurston County because I've done more footwork than anybody else up here. I've done the one doing law enforcement. I'm the one that's getting paperwork from one office to another there. I'm the one that's going out and working every day. I'm the one that's supporting the law enforcement here. But yet you guys turn around and leave somebody kids in an endangered home there with a loose gun there
So, Mr. Miller,
And allow that to happen
So,
and
yeah.
an assault.
Okay.
That is enough.
Yeah, so listen, or yeah, I'm
It's
sorry,
time to
Mr.
go.
Yeah,
Get
so
your
that's
stuff, let's
that's the
go.
decision. I understand you're frustrated. The things you're being frustrated, you're still not talking about how you feel endangered by your daughter, though. So I just want to make sure we're focused on what's at issue here, which is how you feel endangered by your daughter. That's different than the kids, right? That's different than Mr. Gill.
And my wife?
Yeah.
Well, apparently it doesn't matter. She
Well,
can do whatever she
No,
wants.
but there's nothing before the court.
Because I've let it go for years. So now I'm put in a position where if I run into her in public, I have to take it into my own hands. Because that's what
I mean,
I've
it
been
happened
left
right
with.
in front of a police officer and nothing was done.
She purposely came at me. He was in the passenger seat.
Yeah,
She came to attack me and we were a block away from her house.
Right.
yeah.
Right. I know.
So
that
it's not acceptable, period.
Right. And we've gone over that, right? And so I understand you're frustrated and this isn't the result you want. That is the decision of the
Okay,
court
I'm
with
gonna
respect to
press
the two of
charges
you
next.
and your daughter.
We're leaving Washington. I was hoping this would at least buy us some time before we move. But obviously, we're again left on our own.
I'll be following charges anyway.
Can I have it placed on record that they are not to go around my children, my home, or my workplace?
No, that's
order.
not the point of this hearing, ma'am. So
Okay.
no,
That's fine. I can do it a different way. That's fine.
thank you. You're free to go, Ms. Miller.
Thank you.
Did I already do any of the sentencing, or did I just let you guys kind of know that I was leaning towards probation and that we needed to have?
I know it's indicated on January 26th of this year, we appear, we discussed the PSI. There was a disagreement as to the restitution. The court says that it was inclined to place the defendant on a concurrent probation, given the length of time between office date
Right.
and the indictment. Then fast forward to February the 9th of 26, the case was simply just reset for restitution hearing. So it looks like you didn't do
And
anything.
haven't actually sentenced yet.
I don't believe you did, Judge.
Okay, and have you, so, all right, ma'am, you're Janisha Leonard. And Miss Leonard's here in three cases. One is cause number 25 DCCR 0297. That is the new theft of property case, a state jail felony. She entered plea of guilty to. And then we have two MTRPs, one in cause number 19-33340, theft of property, and 20-36095, a theft of service. And in each of those cases, is she on a deferred in both of those? Or is it straight? I'm trying to, sorry, I should have. Is it a deferred probation?
Let's see, Judge.
No, they're straight probation, Judge.
Okay.
Yes.
So they were deferred and then we were here. And then revoked that deferred and reassessed and did the 2/5 at some point. Is that correct?
The last information I have in my files is that she was on a straight post-conviction probation. I don't know if she initially was on deferred or not.
Yeah.
I don't
okay.
know.
All right. Yeah. Okay. So the biggest issue that one of the bigger issues that I had when we were here for sentencing, based just on paper and the appearance of this, I don't disagree with Mr. Coleman's assessment of the case with the criminal history of Miss Leonard with these types of offenses, and which the criminal history is these three cases. There aren't any other cases. And the new offense date was August of 23. And it's kind of just unknown. It sounds like why that case was delayed in prosecution. Doesn't look like anybody knows. And so the time frame between that and now, and the lack of any other cases while Miss Leonard has been out and on probation during that time and doing well, it looks like otherwise on probation, is what leads me to potentially move forward with continuing the probation potentially on the others and giving her a probation on this one. So there was no agreement on any of these, but it looks like there was an issue with regard to the amount of restitution. So let's go forward with that. Have you guys come to any type of agreement on the restitution?
We are very far
We're
apart.
very far apart, Judge, and I guess one of the issues that we have is I believe Mr. Coleman's got some exhibits that are going to go back to 2022. I would object to looking at anything outside the range in the indictment. The indictment goes from August 23, and we'll get to the exact dates.
Let me get it pulled up as well.
August 24th, 23 to September 4th, 23.
Okay,
I would ask that we remain in that range.
I would think legally that would be probably what I would need to do.
Judge, it's a continuing course of conduct. The theft is, I'll be honest, Mr. Ross just brought that to my attention this morning. I haven't had a chance to research it, but he certainly has had all of the restitution information showing that it's going back to 2022 in that discussion. So it's not an unfair surprise for him to know that we're looking for restitution going back.
Well, but I think the allegations, and obviously I understand the honor about as well as any of you guys, but those are some pretty specific. I mean, that's a very short time frame that is alleged in the indictment. Talking what, 4 days?
Well,
5 days?
yes,
Well, yeah,
from August 24th, 2023 to September 4th.
I'm sorry, I'm looking at an old indictment. I'm sorry, hold on. I was looking at another
About
case.
10 days, maybe.
Hold on. So in the new calls number. So yeah, this one is August 24th of 2023 through September 4th of 2023. So less than a couple of weeks, a couple of weeks or so is the allegation. And I don't want to have to keep coming back here. But I think to go back, if it was a few weeks off or a month or two off, but if we're talking years of requesting that, then I think that's something that indictment needs to allege. And so we can go forward with that time frame today. I think legally that's where we need to be. She's already pled to it, so I think it's kind of late to amend the indictment. So with regard to the time frame of August 24th through September 4th of 2023, what is the amount between that time frame? Do you guys have that? Or need some time to look at it again to make? And I mean, and the unfortunate, I want to make sure you guys know how I am. If someone has had something stolen, I want them made whole as much as possible. I just don't think we can go back
Sure, Judge.
that far legally. So I make sure that the victim understands that as well, that we've got kind of a limited time frame here that we need to move forward on if I'm going to order restitution and probation. Y'all need a minute to do some math?
Just a
on-
quick minute, just.
Yeah, y'all, go ahead, y'all have a seat based on, I guess, that. See if there's something you guys agree to as far as that time.
Just based on an on or about date, and they understand that the court's willing to kind of go back a number of weeks. I've got receipts to go back as far as, I believe, August the 9th of 2023. I don't know that would necessarily be, I think that would be enveloped in the on or about. I mean,
I wouldn't disagree with that.
so
So August 9th, 2023. And then what was the last?
the last.
Is
one
that the
was-
September 4th date?
The last one is, I don't want to misquote. Let's see here. September the 4th is the last day.
All right, so you guys figure out what between August 9th and September 4th of 2023 number is and see if there's an agreement on that number. If for some reason there's not, then I can take a look at the receipts that you guys have and then we'll go forward. I'll hold it for a few minutes. Okay, we're back on the record. Cause numbers 25 DCCR 0297, 19 33340, and 20 36095. y'all have an opportunity to kind of go back through the receipts as far as that time frame legally that we can kind of talk about on this case?
We have, Judge. With
Mr. Coleman came up with a number of $2,407. In speaking with Ms. Leonard, her recollection actually is a little bit more than that. She thinks somewhere between $3,000 and $4,000. We had agreed to, or we had offered $3,500. And I think that Ms. Leonard feels comfortable paying back as far as restitution.
So if she agrees that it's between $3,500 and $4,000,
Between
then
$3,000
I'm
and $4,000.
3 and 4, I'm more inclined to go on the higher end of that, just based on the nature of the time frame that we're unable legally to look back on. And so I would be inclined to order the 4,000, Mr. Coleman.
Judge, that makes perfect sense. I've spoken with the complainant who is here today, the district manager for Sutherland's. His position is he'd like to be heard by the court. He was thinking that if the defendant was placed on probation, that they'd be getting a lot more in the way of restitution. I explained to him how we arrived at where we are, but he still wants to address the court and quite possibly ask the court to reconsider. If he's not going to get more than what he's getting in the way of restitution, he would want the court to reconsider some type of form of jail time.
Okay, and sir, you can come on up. Miss Leonard, if you'll just kind of slide around.
Right, for the record, the witness's name is David Powell.
Thank you. Good morning, Mr. Powell. Thank you for being patient with us this morning. It was a big morning here. Mr. Powell, would you please raise your right hand?
Yes.
Do you swear affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
All right. Thank you, sir. And Mr. Powell, you kind of heard where we are on this legally. I understand there's a significant amount of restitution that you believe could potentially be owed based on some prior dealings that aren't within the time frame that we're talking about. Is that correct?
That's correct.
And I'm going to just, if it's okay with everybody, just let Mr. Powell tell me what he needs to. If there's any questions of him after that, I'll gladly let you guys ask questions. But Mr. Powell, you can go ahead if you would like.
I don't have any questions. Tommy explained to me what the restitution would be. We lost a substantial amount of money.
Sure.
And if that's what we're going to be awarded, I would prefer jail time versus the restitution.
Okay. I understand that completely. Anything else that you'd like to say? Thank you. Go ahead, Mr. Coleman.
Just really briefly, Mr. Powell, was any of these losses covered by insurance?
No.
What, if any, effect did it have on Sutherland and its practices going forward?
Other than the loss of funds, quite a few effects. We had to change the way our IT department had to change the way some of our transactions are rang, and that they can be rang and returned and voided. Myself, I'm a district manager, so I manage several stores. So myself, it added quite a bit to my duties as far as verifying reports, verifying voids, verifying where transactions are run, and looking at each store transactions daily and talk to the managers to verify why this transaction was rang in a certain way and why it was voided. So it adds quite a bit more to my morning. Before I can get started on my store, which is Beaumont, I have to verify the other stores, and I have to go through and do a lot of extra work.
And Mr. Powell, we are cutting this down a lot more than what you and I kind of rehearsed or scripted. Just high level, 30,000 foot level for the judge. We have documents here that will show that this defendant essentially engaged in a scheme of enlisting other people or asking other people, but unbeknownst to them, to void transactions and later on remove money from the register. Am I dumbing it down too much?
No, that's actually correct.
Okay.
That's pretty much how we found it, because it was a set pattern. The way the system works is if you void a transaction, the transaction disappears. So if you void a transaction and take the money out, we don't know because the money's gone, because the transaction's gone. What was happening was a transaction will be rang, the customer pays cash. I reprint the receipt so I know how much to ask for a void for. They would void the transaction, and now I know how much money to take out of the drawer. So what I get in the morning in the past, on my reports, it just says there was a void on, done this day for this amount of money. It doesn't say why or how much or who. Now, and of course, with me trusting my cashiers and my office crew, we have a void and it says that the customer paid with a card and not cash. I assume that that's what happened and I let it go.
We've got 139 pages of documents, and these documents essentially show 68 voided transactions totaling 31,000. No, excuse me. Yeah, $31,134.86, going back to July of 2022. Correct.
Good.
State offer states too, Judge.
I would object to any portion outside the date range in the indictment, Judge, but other than that, I don't have any objection to it.
I mean, it's been testified to. I don't think I need those, as I'm going to take it into consideration to the extent that I think appropriate. Obviously, the amount have limited, but the fact that there was potentially more that for some reason wasn't in that indictment, I will take notice of that.
As the witness, Judge.
Thank you. Anything, any questions?
No questions for Mr. Powell, Judge. I know he's been here at every court date. I want to
Yeah.
first apologize to him for having to come here and thank him for being here as well.
Thank you very much, Mr. Powell. You can have a seat. I mentioned earlier, and I think I mentioned it really erroneously, that Miss Leonard had been doing well other than the offenses on probation. It looks like there was issues with community service and lack of doing community service. It looks at only 1 hour of community service had been done. As of March 13th of 2024, 20 hours, October 30th of 2025, after being on probation all this time. So it looks like there was some issue with that. Financial compliance, it says, has been poor. Restitution obligations remain unaddressed. And so she still hasn't paid back the restitution that was owed in the first case to Specs and the second case to Cons. Is that correct?
Has she made up any community service hours since
She's
she
done,
quit?
she's done just 31 overall,
31.
31 hours, yes, ma'am.
All right, well, I'm not real sure that I'm on the same page that I was before, so I'm going to go ahead and allow new argument based on Mr. Powell's testimony, as well as just kind of where we are now. Mr. Rojas?
Yeah, Judge, we asked the court to keep her on probation on the two previous cases and grant probation in this new case. As the court's already said, there was a delay in filing the new case. She has not been a perfect probationer, but certainly doesn't appear that she's had any new offenses. In the meantime, she's had a newborn baby. I believe that was one of the reasons the court let her out on bond when we had the bond hearing. You know, since we've been to court and since these new cases have been filed, it appears that she's been staying out of trouble. She's at least able to do that. And as to the not being able to pay the restitution, Judge, I think she's wearing her uniform today. She's working at McDonald's, not making a whole lot of money. So restitution is going to be tough for her, no matter how much it is. So we ask the court to consider all that and go along with the court's previous leanings and keeping her on probation and giving her this new opportunity on the new probation case.
Okay, Mr.
I'll be brief, Judge. I think the facts speak for themselves. Judge, I'll just direct the court's attention to page 3 of the PSI, the very first paragraph, where the defendant said, "I let a customer walk out of the store with unpaid merchandise, and he paid me instead." Judge, that's I don't have the words for how that's so understates the 68 voided transactions over over the course of a year or so, Judge, to the tune of $31,000. A theft from Specs, a theft from Cons, and now a theft from Sutherland's. She's a serial employee theft offender, Judge. And I get the court's tendency and leaning to give people second chances and try to recover restitution, but the state's position is, but it always has been, is that this case merits some form of jail time.
Just a second, look at one more thing here. And Ms. Core's here today as well. And Ms. Core, do you have anything to add?
Judge, just that I got her case back in May. And she was transferred to the high needs caseload because she thought she was getting evicted. And that's why I have her on my caseload now. But it's been sort of slow progress with her. Her just doing the community service hours just October after since 2021. She's been on probation. And she has been making some good faith payments, but she hasn't really addressed the restitution yet.
Have the payments been redirected towards restitution first, or are they still going towards the probation fees?
They're still going towards the probation fees.
Do you have anything to say, Ms. Leonard?
Yes, ma'am. Lot to say. I know we probably don't have that much time, but I'm sorry. I take full accountability for my actions. I wasn't the best person. I didn't really care about things I didn't have. I felt like I didn't have anything to live for. I didn't have nobody, I woke up every day and just went with my day. But I'm a mother now after 3 miscarriages and being told that I'd never be able to. I take care of my child by myself. Her dad's not in her life. The only help I have with her is my mom. And my mom's a single mother of 4 herself. So, like if I'm not at work, my daughter's with me. I do everything by myself. Doctor's visits, cardiologist visits because she has heart murmur, dentist visits. I do everything by myself. I'm not that person anymore. I never believed that I had a reason, but I have a purpose now from what I, believe.
I mean, you don't deserve another chance. I appreciate obviously the change in your life and how that can be very substantial. But I don't understand. I don't think Mr. Coleman was a part of, obviously, why there was a delay. That still gives me some pause in the case is for whatever reason, this sat somewhere in intake or at the agency. We're not sure which, why this case was delayed. And really basically for that reason and the fact that there has not been any new allegation since October of 2020. Well, this allegation was from August of 2023. And here we are in March of 2026. And there hasn't been any new allegation. And I just don't understand the length of time. And Mr. Powell, completely understand your position. There are some other things, obviously, too, that I'm taking into consideration. But Ms. Leonard, if I give you an opportunity today, I don't know how many jobs you've got to get, but you're going to pay some restitution or you're going to go to prison.
Yes,
Period. That's it.
yes.
I don't anticipate probably that you can pay it all in all of these cases, but you're going to pay some restitution.
Yes.
You're going to be on probation for a very long time to be able to do that because I can extend your probations for a very long time. And so if you really have changed your life and want to be there for your daughter, you're going to be given that opportunity, but you're going to do different. Or else you will be back in here and I'm not going to hear any, I have a baby and tears and all of that.
Yes.
Not going to listen to it. Do you understand?
Yes.
So what I'm going to do In cause number 19-33340, I'm going to find sufficient evidence to revoke your revoke your probation, but I'm not going to do that. I'm going to continue your probation. I'm going to extend that probation for 5 years. And then I will go through some specific requirements on all of the cases in a minute. And then in cause number 20-36095, also find sufficient evidence to revoke your probation, but I'm not going to do that. I'm going to continue you on probation, going to extend that probation for 5 years. Order, obviously, that you follow all of the rules and conditions of probation, including completing your community service and paying more towards restitution. I'm going to find in cause number 25 DCCR 0297 sufficient evidence to find you guilty. And at this time, I'm going to find you guilty, sentence you to 2 years into the state jail prison, but probate that for 5 years. So I could only probate it for 5 years at the beginning. So you're on probation for 5 years. There won't be a fine in that case. There will be restitution owed in the amount of $4,000. I would like for all of Ms. Leonard's payments to go towards restitution. At this time, it can be divided amongst them, however you guys feel appropriate. But at this point, we need that money going back to the victims.
Yes.
And so let's do it that way. And then Ms. Leonard, you're going to remain on the high medium caseload. And also you're going to be under zero tolerance.
Yes,
Okay. So there's no more whatever. It doesn't matter. It doesn't matter if you miss an appointment. Obviously, if you commit a new offense, test positive, you don't pay restitution, if whatever it is, doesn't matter to me. One thing means you're back in here and you're looking at those 3 2-year sentences, and they can be stacked because this one was convicted after those other 2. So I think we probably can only stack 2, and which means you could end up with a 4-year sentence instead of a 2-year sentence. And I can assure you that Mr. Coleman will remind me of today. He will remind me of Mr. Powell. I typically don't forget things like this. I don't remember a lot, but when we've gone through this as much as we have, it's never a good thing when I remember you or your name, and I do now. So you don't want to be back here in front of me because you now have 2-year sentences. There's no negotiation on whether or not you get less than that. If you violate, it's 2 years in the state jail on every single case because that's your sentence. And then the only determination that would be made at that time is if I stack it or not. Does that make sense?
Yes.
All right. These were not agreements. So there are some limited rights to appeal. You can talk to Mr. Rojas about that. I'm handing you the trial court certification. Also handing you a certification regarding your ineligibility to possess a firearm or ammunition. I went over that before, I'm sure, but you were ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition or about how long that lasts, you can talk with Mr. Rojas. Probation, you need to stop and talk to her. She's going to go over all of that paperwork with you. Thank you, Ms. Ford. Thank you, Mr. Coleman and Mr. Rojas. And thank you, Mr. Powell.
Mr. Gibson has been spending a large portion of his morning communicating with Mr. Brandt in the lockup with the assistance of a American Sign Language interpreter. Before we bring him in, what's our game plan here, Mr. Gibson?
Well, I have been going over the situation with him for quite a while in the back, and it sounds like he's not, he gave one possibility that he would waive, and I checked with the prosecuting attorney and they indicated that they're not willing to do that. So apparently at this point, he's basically asking for exams, but he hasn't necessarily told me he wants an exams, but he won't, in a sense, he's not willing to sign the waivers.
All right, well, let's bring him in. I've known Mr. Brandt for a long time. He is frustrated. His whole life he's been frustrated because he can't make himself understood. Sometimes he talks quickly and we've been kind of fumbling by with the
ERI.
no, a live caption, closed caption on the computer at his end and at our end. It doesn't always accurately capture exactly what's being said, particularly what's being said by Jack. He himself says his ASL isn't the greatest, but I know you've worked with him before. And have you worked with him before?
No, this is my first time.
All right. Good morning, Mr. Brandt.
I might take these off so I can sign.
You mind taking these off so I can sign?
Please, thank you, your honor.
Please,
Excuse my manners.
I understand. Yes. I've known Mr. Brandt for a long time and I think we'll be fine. But he does need the use of his hands.
Yes, your honor. Thank you.
Yes,
Thank
thank you, your honor.
Thank you, Deputy.
Thank you. Thank you, Mr. Bank. Command.
Thank you, deputy.
Are you Jack William Brandt Jr.?
The second, yes, your honor.
The second, your
The
honor.
And we've met. I'm Judge Middleton. We've got the assistance of two ASL interpreters to help us today.
First again, the honor, because I wanted to have a 100% effective communication.
I appreciate that, your honor. I want to have 100% effective communication.
You met Lindsey Brown back in the lockup. Also assisting us is Erica Allen. And you have worked with her before. Both interpreters have been sworn in to assist. You and I have been trying to communicate as best we can using the closed caption.
Yeah, that was a little tricky because the closed caption is not always 100% effective because the word can be mistyped or whatever. So that's why people have two live interpreter, and I really appreciate that, your honor.
Well, you're exactly correct.
Thank you.
All right, you're here with your lawyer, Mr. Paul Gibson. You have two felony cases. The first one is file 26152FY. That alleges 2 counts of resisting and obstructing a police officer. Those are felonies, punishable by up to 2 years imprisonment. And a fine of up to $2,000. And you're alleged to be a 4th habitual offender, which would make those punishable by up to 15 years imprisonment. In that case, you are also charged with domestic assault 2nd degree, 2nd offense, which is a misdemeanor, punishable by up to a year in jail and a fine of up to $1,000. You were released on bond in that case, and you got arrested on a new case which is 26224 FY. In that case, it is alleged that you made an indecent exposure of your person and that is
Yeah, that was,
that's the charge. It's not proven at this point.
okay, okay.
That is a high court misdemeanor punishable by up to 2 years imprisonment as also a fourth habitual offender. Chief Assistant Prosecuting Attorney Joshua Robert is here on behalf of the people. He has been discussing this case with your lawyer, Mr. Gibson. If I understand the plea offer correctly, the prosecutor has agreed to dismiss the 2 counts of resisting and obstructing a police officer and the count of domestic violence second offense. If you plead to domestic violence first offense, which is a misdemeanor punishable by up to 93 days in jail and a fine of up to $500. And if I understand it, that plea would be taken in circuit court. The other charge is more problematic. The prosecutor has offered to dismiss the habitual offender portion of the indecent exposure charge. If you plead to aggravated indecent exposure in circuit court. In order for that to happen, these matters would have to be bound over to the circuit court. That means the case is transferred to the circuit court for their jurisdiction. This court only has jurisdiction over matters that are punishable by a year in jail or less. And that is a 2-year misdemeanor. In order for the matter to be bound over, we either have to have a preliminary examination where testimony would be taken under oath to establish probable cause that you committed these offenses. If you waive the preliminary examination in these matters, the entire set of cases would be bound over to circuit court for potential entry of these pleas. But you don't have to plead to anything because you're presumed to be innocent. If you wish to have a preliminary examination in these matters, that could be set for probably next Tuesday afternoon. So the question here this morning, Mr. Brandt, is do you wish to waive these preliminary examinations and have the matter bound over to circuit court? Or do you wish to have testimony presented regarding these offenses in a preliminary examination hearing?
Let me discuss with my lawyer real quick. Just want to read. Oh, yeah.
I was going to say that.
Just a minute. Mr. O'Bear wanted to add one more thing.
Mr. Gibson raised some concerns regarding the effect of the indecent exposure conviction for his client. If he waives this case to circuit court, it leaves the option to further negotiate on these files open. And if he were to get out on bond and show us that he can not get in further trouble, that could have an effect on the plea offer. But if he has a preliminary exam, in particular on that file, there would be no further negotiations on that case.
Mr. Brandt, that's pretty common. If you waive these preliminary examinations, it would leave open the opportunity to continue to negotiate the case to try to resolve it. But if you have a preliminary examination and you are bound over, the prosecutor would revoke any plea offer. In fact, that's how I used to do it when I was prosecutor many years ago. So if you wish to discuss waiving these with your lawyer further, we can either have you go back into lockup or you can try to discuss it right here.
Your Honor, you indicated that on the first case, he's posted bond. Is that bond still in effect or has that been canceled?
It has not been canceled.
And then what is his bond in this new case, the second case?
$5,000 cash or surety.
Okay. Mr. Brandt is indicating that he's willing to waive. I have the waiver forms here.
All right, let me go through these with Mr. Brandt. Mr. Brandt, you and I had a discussion the last time we talked. I have known you for a long time. And you said people all your life think that you're dumb. And I told you that I did not think that. The fact that it's difficult for you to communicate doesn't mean you aren't intelligent. You have always been appropriate and respectful to me in my court. And I don't think that you're dumb. I think you know how to make decisions. Sometimes you make some bad decisions. But my understanding is your decision at this point is to waive the preliminary examination in both of these cases. Is that correct?
Yes, for the indecent exposure and for the R&O.
Yes. Let me read that language to you. Mr. Gibson has got both waivers and he'll have you sign them. It says, I, Jack William Brandt II, understand I have a right to employ an attorney. I may request a court-appointed attorney if I'm financially unable to employ one. And here's the important language. I voluntarily waive my right to a preliminary examination and understand that it will be bound over to the circuit court on the charges in the complaint and warrant. In each case, is that what you wish to do? All right, go ahead and sign those two bindovers. Emmett, would you take those over to Mr. O'Bear? In addition, Jack, the prosecutor has agreed not to pursue the bond violation for you getting arrested on the second charge while you're on bond on the first charge. So if you could post the bond in the second case, get out, stay out of trouble, it would help your cause.
Yes, I will, Your Honor.
Please, I'm not peace out.
And I'm not saying peace
So
out.
I'm sorry, so Erica got involved. I've always been a peaceful man. I mean, shit, I have
I've always been a peaceful
too
man, Your
much
Honor.
frustration,
It's just
hardship in my
frustrations and
hometown.
hardships
Because
in my hometown.
I had a lot of good friends, but they all left and leave me, shunned me, abandoned me because I'm deaf. I'm just very sick and tired of being oral all the time. Because I noticed my sign skill is dwindling because I don't have any different community to socialize with. That's why after I'm a good, heartful person. I learned that from my grandfather, one Grant Senior. He's the one who taught me how to hunt, clean, fish, everything. Taught me how to be a world-class gentleman. And I want to get out of here for my mental health sake. On February 10th, 2026, I know I broke my bond, but I was.
All right, don't say any more about it.
Sorry, my bad.
All right, you're free to go. This matter's completed.
Thank you, Your Honor.
And, hopefully you can post your bond and Judge Stutzman will handle the case from here out. Good luck to you, sir.
And I'll promise to stay out of trouble.
And I promise to stay out of trouble.
That would make me happy.
Yeah, have a nice day. Yeah, have a nice day in your heart. It's good to see you again. I'm sorry. I know I keep making a lot of time not to be here, but
We'll be all right. You're good to go.
yeah. And yours. Oh, shoot. My bad.
All right, Mr. O'Bear, I'll
Yeah.
get those bindovers from you
Yes.
and, all right, that completes our docket for this morning. Thank you all for your patience.
We are on the record in the matter of Sweta Ravel versus Caltech Services, doing business as Caltech Plumbing, Heating and Air, 2500386. An appearance for the plaintiff, please.
Good morning, Your Honor. Mark Thomas Bedari on behalf of Ms. Wall, who's also in prison.
Thank you. Ma'am, your name for the record, please.
Suita Ravel.
Suita. Okay, I apologize for that. And counsel?
Good morning, Your Honor. Good to see you. Ron French here on behalf of the defendant.
Thank you. And your name, sir?
Cal Nagy.
I'm sorry?
Cal Nagy.
I need you to please spell your first and last names, please.
It's KHALED.
KHALED. Okay. Oh, Khaled. I only heard the first syllable. Okay.
Nagy, NAJI.
Okay, I apologize. I only heard the first syllable of your name. Okay. All right, I'm going to have Ms. Raval and Mr. Nagy, please raise your right hands. Do you solemnly swear or affirm the testimony you're about to give in this matter be the truth, the whole truth, and nothing but the truth?
Yes.
All right, thank you. And Mr. Bedari, I know that you're a very soft-spoken man, and I just need you to keep your volume up when you're speaking, okay?
Sure.
So we can make sure we have everything recorded.
Is it okay if we use the microphones at the table, or do you prefer us at the?
Yes, no, that's fine. I just need you to still keep your volume up so it's being recorded.
I Thank you for the right raft.
To be closer to the mic, or do you want us to stand, Your Honor?
Well, just stand when you're addressing the court. But here's what I understand. I understand that the issue that is before the court right now on the motion for summary disposition, your clients can both have a seat, that's fine. Is that Ms. Raval is not the one that signed the contract with Mr. Najee, correct?
That's true, Your Honor. That's
Great. Let me see the contract. Where's the contract?
Yeah, that right here, Your Honor. That's part of our pleadings as well. The conditions are with that as well.
Just one moment. Who owns the home?
I do. Oh, sorry.
Who owns the home?
The plaintiff does that.
Okay, who's Mr. Mendoza?
That is, the plaintiff's fiance who we, requested an authorized. Mr. Mendoza present at the initial, inspection and, appraisal of the problem, on December 4th. As was, Ms. Raval, she advised, their technician Dakota is, my understanding is the gentleman's name. She said, because I'm a teacher, I cannot be here, during, the business hours. December 4th, I believe was on, I'm sorry. Yeah, December 4th was a Wednesday.
Okay, let me cut you off for just a few moments. So your client is the individual that initiated the service call.
Yes.
Okay. And so she indicated that her fiance would be at the home and would be the point of contact, correct?
That was, I didn't want to, that was for the scheduled prepare date. The assessment, the diagnosis, the cost, estimate of repairs and so forth. Ms. Raul was there along with Mr. Mendoza, and she advised Dakota that because of my work schedule, all communications, if you need to schedule the appointment, Mr. Mendoza will be there as he was on December 11th, which is the first scheduled date. Your Honor, there is one document I would like to add.
Okay, so I will review that document, and before I receive that document, so Mr. French, is your position, because the name on the invoice here created by your client says Daniel Mendoza, that this is the incorrect plaintiff?
That is our position, Your Honor. There was no correspondences, according to my client, with her. They were all with Mr. Mendoza. I have text messages as well from Mr. Mendoza showing that. And he actually canceled the contract in the text messages as well. That's our exhibit 2 and 3 with the plea.
He canceled the contract.
He did say, just give us our money back. And I got that with me. If you'd like to see that, it's in our pleadings as well.
Who canceled the contract?
Mr. Mendoza. He was the one that had all the correspondences. It's my understanding that he even called the company to get these guys out, according to my client.
Okay, so let me ask this question, just a maybe logical question, maybe not. So your client's position or your position is that since Mr. Mendoza is the individual that whose name is on the invoice as exhibit 1 here, showing, which the court will note, it's not necessarily been admitted for an exhibit, but that's what I'm referencing here, is that Mr. Mendoza is the proper plaintiff.
Right.
However, so let me ask this question. So if Miss Raval owned the home and she rented it out, okay? And the tenant is the one that was the one making the contact with the company, but wasn't the owner of the home. Are you telling this court that the owner of the property wouldn't be able to file the action?
She's not the one to contract.
Counsel, that's not my question.
Yes, that's my position, that she's not the plaintiff.
No, that was not my question. Please, here's my question. The landlord of a property contacts a service company for service of, I don't know, plumbing, okay? In one of the apartments. the apartment tenant is the one that's there, greets the individual there for service, and perhaps that's the name that the invoice gets put under, or the name of the person that lives at the apartment being fixed. And let's presume that the landlord was not happy or satisfied with the work. Are you telling this court that the landlord, the owner of the property, is not permitted to file an action because they were not the one that was named on the invoice?
Under those circumstances, it's a maybe, but that's not what we're talking about here. This is not a landlord-tenant matter at all.
I understand that.
Person who contacted our people, said, come out, dealt with them, signed the contract, was there, dealt with my clients, actually got into it with them on the text messages. We have had no correspondences with the named plaintiff.
Okay.
So, I mean, the contract is pretty clear. And by the way, if you read the second part of it, the forum is bad here as well. It's not the proper forum. There's an arbitration clause that's involved in this matter that was part of the contract. You have that.
Okay.
It's section 23 of the arbitration clause. It says clearly that any and all disputes involving this contract and this work will be taken to the American Arbitration Association for settlement purposes and for argument purposes. And then
Okay, hold on. So you're talking about this Caltech heating and cooling terms and conditions?
yes.
Okay. Mr. Badari, did you have an opportunity to review that?
I did, Your Honor, but my interpretation,
No, hold on, I just want to know if you reviewed it.
it's attached to his motion.
Okay, so let me see here. Okay, where's the signature page that attached to your motion?
That goes with the contract, and he signed it, and that was given to him, and that was the agreement.
No, where's the signature page? On this one that you provided to me, I don't have a signature page.
Your Honor, with the contract, that's all one packet. It's like,
So there's no signature on the terms and conditions part of it?
no, the
Okay.
terms and conditions.
So this is the contract?
Second page of that is the signature for that entire packet.
This is what you're calling as a contract?
Turn the page, you'll see the agreement.
Counsel, I know that there's a second page. I'm asking, this is what you're saying is the contract?
Right. Agrees to the agreement for work. They had no,
This looks as though it's a quote, not necessarily a contract.
that's the agreement, Your Honor, for the work.
This says description of work.
Right.
And this doesn't have, this references terms and conditions. All right, so Mr. Badari. Paragraph 23 of the terms and conditions indicates arbitration of disputes. Any controversy that develops between contractor and owner with regard to matters arising out of or relating to this contract and that the parties do not promptly resolve shall be decided by arbitration administered by and in accordance with the construction industry arbitration rules of the American Arbitration Association, unless the parties otherwise agree in writing. This paragraph shall be specifically enforceable under the prevailing arbitration law. The award rendered by the arbitrators shall be final, and judgment may be entered on it in any court of competent jurisdiction. So, has there been anything in writing that would suggest the parties agreed to not proceed to arbitration with any conflicts that need to be resolved?
Your Honor, if I may. Defendant is asking to have its cake and eat it too. They are arguing.
Hold on, counsel, my question was, is there anything in writing that says the parties agreed to resolve this outside of arbitration?
No, Your Honor, and I don't believe one is needed in order for this case to be brought before this court.
Well, that's what paragraph 23 says.
There is case law, Your Honor, which I wasn't prepared to brief this issue. I thought the limited purpose of today's evidentiary hearing was as to whether or not Ms. Laval was party to a contract, whether she has standing to be the plaintiff in this case. Enforcement of the contract, I think, is putting the cart before the horse, if I may. And I'd be happy to address that, but I was not prepared to go over the.
Well, I don't know that I can even get to whether or not the plaintiff has standing if this matter isn't even supposed to be before the court.
Well, I disagree that that can be enforced, so that, dismissal of this case is mandated.
Well, why can't this provision be enforced?
That issue was not before the court, Your Honor. It does not, that is not part of the motion to dismiss. I did not see that. He's now, defense counsel is now raising, as the appellant, but that, if you look at the, motion itself, all the addresses is, the proper party, why if the conversion, should not, be granted, why, and other issues related to the counts of our complaint. It does not, nowhere does it say that, the provisions that Ms. Raval is not, a party of, they're asking you that Your Honor dismissed Ms. Raval, dismissed the complaint because of standing. Nowhere did they raise that before, so I'm not prepared to address that at this time, other than, if you brief on that, I'd be glad to submit that. Your Honor, if I may.
Not yet. So counsel, Mr. French, I'm looking at your answer to the complaint and special affirmative defenses. I don't see anything in here about this matter not being in the proper venue because of the arbitration clause. Further, I see something in here regarding an allegation of affirmative defense of statute of limitations, but hasn't this only been it's only been a year, 16 months. Okay. Also, just one moment. Let me see here. Your motion for summary disposition. And Mr. Badari seems to be accurate that there wasn't any issue raised in your motion for summary disposition that this is not the proper venue. So if you're alleging that now, why didn't you put that in your motion for summary disposition?
Your Honor, I thought it was part of the contract because it was the initial agreement signed by a different party, Mr. Mendoza. And the whole issue in this case was the delay in getting this furnace repaired.
No, hold on. You're okay. You're sidestepping my question. You are asking for this court to dismiss this action because it's not the proper venue because of the arbitration clause. So then why did you not put that in your motion for summary disposition?
We didn't specifically, Your Honor, to answer your question.
Okay, well, where is it? Where is it in there, kind of, but not specifically? Where's that in the motion?
In the motion, in our breach of contract claim fails due to lack of standing. Part of that, the undisputed evidence shows that the service agreement, which we're looking at and has that clause in it, was signed by Mr. Mendoza. We thought all the communications.
Well, I'm sorry, counsel. I'm sorry. I'm not following where you're saying.
Oh, in our motion, Your Honor.
Right, what page?
Let me see. That's where we start the arguments. It's page 5, Your Honor, is where we start our arguments. And this is just one of the issues.
Page 5 of your motion for summary disposition?
Yes. Can
My page 5.
Can I approve the motion?
My page 5 is your signature page.
Oh, there's 2 motions, Your Honor. Maybe that's the wrong one.
Okay, so hold on, please. This is the one dated November 13th of 2025. It's not that one?
Can I approach the show, Your Honor, and be a little bit more clear?
What does the date show on your motion, counsel?
On the signature page? November 13th.
Well, that's what mine shows. So yes, I'll take a look at yours that you have because that seems to be different from the one I had printed off of my file. Oh, this is the brief, not the motion. I'm looking at the motion. You said the motion.
I'm sorry.
The brief. Not they're not, the pages aren't numbered either. Just for future reference, they need to be numbered, counsel.
Yes.
I believe that's what the court rules indicate as well. So you're on page, let's see, the legal standard. All right, well, in your paragraph, it'd be the last paragraph before your legal standard bolded headline. halfway down, well, it's the last two sentence, well, the second to last sentence. It is defendant's belief that there is no factual issue which would require a trial, as plaintiff has failed to state a valid claim, and that defendant has proven his case beyond the preponderance of the evidence. There's nothing in there, in that portion of your brief, that would suggest that this court lacks jurisdiction because of the arbitration clause. And then you want me to go to lack of evidence? Is that where you wanted me to go to?
Well, I thought we covered it.
Oh, lack of standing.
I thought we covered the agreement and the breach of contract issue.
Okay, let me read that.
Because there's two things in that, Your Honor, that.
Hold on, counsel, please. All right, again, there's nothing in this breach of contract provision of your brief that it alleges anything about the arbitration clause. In fact, it talks about how a party who's not party to a contract cannot sue for breach of that contract.
There is.
And then there's another portion that even if a valid contract existed, it was frustrated by two superseding events outside of your client's control. Neither of those indicates the arbitration clause. So I'm not proceeding on any of that argument today because that's not before the court.
How about the second argument, Your Honor? Any delays, which is in the agreement, I think it's the last paragraph in the agreement says that the contractor will not be responsible for any delays.
Where are you at now?
That
In
is
the brief? Are you still in the brief?
It's in the
All
agreement.
right. Well, hold on, counsel. We're in the brief because you told me that you addressed the arbitration part in this portion of your brief. So now let me jump to this agreement here.
Your Honor, it's our understanding that.
Hold on, counsel. Let me get to where you're at. So what page are you on? The last page?
Last page of the agreement. Your Honor.
Delay, paragraph 27.
Yes.
All right.
So let me set that, can I set that up for you, please?
Set this up for me?
Yes.
Just one moment. Let me read this. Contractor shall be excused from any delay and may be entitled to an increase in the contract time due to any of the following events, provided that such event is beyond the reasonable control of contractor. Acts of God, including but not limited to wind, rain, flood, storm, landslide, subsidence, pandemic, disease, and earthquake. 2, acts of negligence of owner. Failure of owner to promptly process submittals, payment applications or change orders. Delays caused by work which is not the responsibility of the contractor. Delays caused by public utilities or government or public bodies and their agents. Material embargoes, labor troubles, labor slowdown, strikes, union activity causing reduction in productivity, none of which is caused or aggravated by contractor. Fire, delays in transportation, wrongful failure of owner to make payments to contractor is required under the contract documents, changes ordered in the work, other causes beyond the reasonable control of contractor, its employees, agents, and subcontractors. Okay, so there's that provision. Now, I'm going to ask a couple questions. There seems to have been 2 issues. One, there was an accident that occurred while somebody was on their way to perform the work or the service. And then there was a delay in parts.
Yes, it was the holidays.
Okay, so when the contract was procured, what was supposed to be happening? A new furnace, a fix of the furnace?
It was just a part, Your Honor, that needed to be taken out and put back in a new part.
Okay.
And
now, this was all December 4th of 24, correct?
right at around that time during the holiday period going forward.
And so what was the part that needed to be repaired?
I think it was a heat exchanger. I'm not sure. Do you remember the part?
Stand up. Oh, sorry. No, I don't remember. Hard.
Well, can you look at your documents?
We don't have those, Your Honor. He wasn't the technician on it. He's the owner. It was the young man named Dakota.
All right. So, all right. So
but for the
there was a part that needed to be fixed. So it's not a full repair. There was a part that needed to be fixed.
Right.
Was the furnace working?
No.
Not at all. Okay. And so part needed to be fixed. We agree on that, correct, counsel? And it was a part that needed to be fixed?
No, it was a part that needed to be replaced, not fixed.
Oh,
The boiler needed to be repaired.
To be
Part of
replaced.
the
Okay.
repair included a new part.
And replaced is fine, that's,
Okay, so
I'll wait.
for clarification, there was something that needed to be repaired, whether it was replaced or whatnot, on the furnace or boiler itself, but not the entire system. Correct?
Correct.
All right. So then, so on December 4th, around that day, this contract is entered into for, service and performance. When was the part, expected to have been installed?
they were tracking it from my understanding with the UPS tracker.
That was my question.
And I'm trying to get to the answer, Your Honor, and
No,
it was delayed because of the holiday.
that's not, no. At the conversation, at the initial contract, or when your client was supposed to perform the work. When, I'm sure there was a discussion as far as time, because it's December and there's no heat. So what was the expectation that was communicated as far as when the repair would be complete?
May I answer that, Your Honor?
Yes, please.
December 11th. And do you know why that is? Because defendant contacted the plaintiff and said, we will come in and do the repairs December 11th. They didn't say, oh, unfortunately, we have to cancel December 11th because of a part. As Mr. French was alluding to, there were some issues that caused, other than the parts, there was something that caused them to not be able to complete the repair on December 11th.
Let me ask this question. Mr. Najee, where do you purchase your parts from?
Several places, online and supply houses.
Okay. All right. So this supply house, you have local supply houses. And so you went to the local supply houses and not any of the supply houses had this part that was necessary.
That particular model serial number, yeah.
And so you ordered it from where?
I'm not sure about that. I wasn't the one that ordering the parts. I had an office person that did that.
Okay. So you have an online account with
Several.
with, let's say, an online supply house. Okay. And so it would be from any of those, right?
Yes, I'm sorry.
Okay. And so when you place an order, or your service team places an order, is there a shipping option?
Shipping.
Okay. And so are you able to get it sooner?
Whatever that was available on there. There wasn't something like overnight. They don't do it overnight.
Okay. So this contract is put forth on the 4th. And so when was the part ordered?
I'm not sure.
Okay. When was the part ordered?
I believe it was right away, and when
Oh, no, I can't have you believe that, counsel. I need to see when was it ordered. Where's the proof of ordering of the part?
I don't have anything in writing on that.
So you want the court to rely on the delay not being the fault of your client, but I don't have anything that tells me when your client ordered the part. For all I know, he could have ordered it on December 10th. I don't know. So I need something that shows when it was ordered.
I don't have anything in writing. His business has been closed down, so that's one of the problems with having paperwork. But I don't have a date of when it was ordered. But typically, in talking to my client, they order them the day they figure out what part is needed.
Okay. So, sir, do you have access to your online ordering system?
Not right now.
All right. Well,
Okay.
so when did the part finally come in?
It didn't come in, Your Honor. The contract was canceled on a text message by Mr. Mendoza. And he says, just send my money back. And that's what they did.
Hold on. When was that text message sent?
December 12th.
December 12th.
Yeah, it's in our exhibits too.
Okay. So,
And I do have the check that was sent.
but it would have already been shipped.
What, the part?
Right.
No, there was a delay in the part. And they didn't get it before that day. I'm sure of that, and he can testify to that. And when Mr. Mendoza texted my client's secretary, she sent the check out, if I have a copy of as well. And it was $616. That's our exhibit 4.
And that was sent back to,
Mr. Mendoza.
okay,
Forgive my interruption,
Hold on,
but we are
okay.
leapfrogging a lot of events here that are
Yes.
in his own motion.
yes.
So
What I'd like to know, what I'd like to know is December 4th is when Mr. Najee's company was contracted to repair the boiler. It's a boiler, correct?
yes, and the check was issued in cash the same day.
Right. All right. So then at what point did, so on December 11th was scheduled. And so did you receive any communication, ma'am? Or did Mr. Mendoza receive any communication prior to December 11th regarding the delay of the part?
No, on December 10th, I think there's an automated like text message they sent in the evening. It said our technicians will be there between 9 and 11. And that's a message that he received on his cell phone, like expect the technician in this window frame. So when December 11th came, after a few hours, no one showed up. So when he contacted the company, and I know this because on my lunch break as a teacher, I'm like, oh, are they fixing it? When he contacted the company, they said, unfortunately, there was another emergency we had to attend to. That's what they said. But we have another technician that works on a boiler that should be out in a couple hours. So then a couple hours go by and he contacted them again. And he said, I'm sorry, the real emergency was that one of our technicians got into an accident. So again, we were frustrated, no heat. So when I came back from work, getting like, this is ridiculous. I just want to just get our money back. And I said, they already have my deposit. They cashed it. So let's just go ahead and work with this company. It's freezing in this house. Let's just go ahead. They have our deposit. When's the next available appointment? So they gave it to us in January.
January was the next available appointment?
Yes. And when January came, the same thing happened the evening before. You receive a text and, our technicians will be there between 9 and 12, and then no one showed up. And when we called, they said, we don't have the part.
Hold on a moment. You went the entire month of December and into January without heat?
Yeah, we had electric heaters everywhere. I live in the 1800s, out there, it goes in the 1800s. So the boiler system heats everything. So we shut down the doors. We had electric heaters everywhere, like everywhere. And I got a rescue pet. So, we were huddled up in a couple of rooms in the downstairs floors, and we had electric heaters.
Okay. So did you at any point receive your deposit back from the defendant?
No.
No. And you're saying that your client sent the deposit?
Yes. Mr. Mendoza on December 12th texted and said, please just send our money back. And the check was sent out and stated for 114. And that's our exhibit for 6.
So, Ms. Raval, what information do you have about that?
Because December 11th, Danny was so mad. He's like, it's freezing. I just want my money back. I told him, I said, you know what? Let's just go. They have $750 that we gave them. So let's just go ahead and have them put us back in the schedule. And that's what we did. There was no money returned. In fact,
well, hold on a moment. On December 12th, I'm showing from Mr. Mendoza, we would like our money back. We can no longer trust your company word. They keep an appointment. And then somebody responds, I completely understand, whoever Jessica is, I completely understand your concerns and want to assure you that a refund will be issued minus the fees for the visit and diagnosis, which are non-refundable. On a separate note, I hope you can appreciate the challenging circumstances our team faced this morning due to an unexpected and serious car accident involving one of our technicians. It's a reminder of the unpredictability of life, and I genuinely hope you don't face such situations. Then the response from Mr. Mendoza. First and foremost, I am concerned about your technician, but I'm also concerned about my family who's been here for 10 days now with no heat and half the house. This is an emergency on our part. 2, there should be no service fees or charge for nothing for the inconvenience that you have caused me today. I lost more than $400 just at my job today. Are you going to reimburse me that? We understand your frustration, but delays happen. Our technician's accident was out of our control. Our technicians' expertise and service come at a cost. This will be reflected in the refund. Both our time and yours are valuable. We hope to find a solution to avoid leaving you without heat, but respect your decision. This has been passed on to accounting to be taken care of. December 23rd. Jessica, I'm working on getting you back on the schedule just a little longer and I'll have a date for you. I appreciate your patience. Okay, so now I'm even more intrigued because if the contract was canceled, why are they back on the schedule?
They were trying, they never got them back on the schedule.
No. Counsel, you're telling this court, you represented this court, that Mr. Mendoza canceled the contract. All right. Yet December 23rd of 24, Jessica tells Daniel, I'm working on getting you back on the schedule. Just a little longer and I'll have a date for you. I appreciate your patience. So that tells me that there is an expectation that they were going to have the service done.
My client tells me that they do follow-up calls on everybody and that it was never rescheduled, Your Honor. That's what he just told me.
Interesting, because Mr. Mendoza says, thanks. Just as long as it's Dakota doing the job. Thanks. The response, yes, it will be with Dakota.
But it was never rescheduled after that.
Excuse me. Then Mr. Mendoza says, thank you. And then Jessica says, I had to resend the estimate to be signed again. Please sign when you're able. I have availability on January 2nd, 8 to 10 a.m. If we have a cancellation, we can move you up. Okay, thanks. Then later on, thank you for your message. It looks like an automated message because it was outside of working hours. And then says, you're welcome, have a merry, and then it's cut off. Then let's move to Exhibit 3, shall we? January 1st, reminder from Calltech Plumbing, Heating, and Air. A technician will be arriving tomorrow between 8 and 10 a.m. Good morning, Mr. And then later on, and then it says proceed to confirm. Good morning, Mr. Mendoza. This is the next day on January 2nd. I was just informed by Dakota that he does not have all the materials. They did not come in due to the holiday. My apologies. I should have scheduled once the parts were in. We thought they would arrive in time. Mr. Mendoza responds, it seems like you guys have no respect for my freaking time. Every time you cancel on me, I lose freaking money from my jobs. You guys are supposed to be professionals. I'm really getting tired of this shit. Response from Jessica. I understand. Hello? Okay, that's what I was saying. Why is it happening? Logging into our phone. I understand it will cancel and issue a refund. I don't appreciate being cussed at. And then Daniel says, I'm on the way down there to pick up my money. I'll be there within the hour. I don't want you mailing my refund. I wanted them in person. At least you can do that for me. I'm on the way down to pick up my refund. I'm on the way down to pick up my refund. I understand we'll cancel and issue a refund. I don't appreciate being cussed at. I'm on the way down there to pick up my money. I'll be there within the hour. I don't want you mailing my refund. Oh, that's okay. Oh, then she responds to the multiple, I'm on the way down to pick up my refund. No, sir, we will have to mail it. I am not able to sign the check. We have a protocol that has to be followed. So I do not believe your client when he says that they were not rescheduled on the schedule, because clearly they were rescheduled in January. Clearly. Because it was even confirmed that it was going to be with Dakota. And then it was also confirmed that Dakota was not going to be able to do it because the materials were not in. So, sir, they were rescheduled on the calendar.
I do agree with that, but the part did not come in. And if you go back to the agreement, that last paragraph that Mr. Mendoza signed, it covers my client for any and all delays. So that
are not the cause of the contractor.
Yeah.
I don't have anything that shows when he ordered the part. Nothing shows when the part was ordered. So I cannot find that the delay was not because of your client, and your client's lack of credibility at this point does not bode well for him, because he has represented to you, counsel, which you now represented to the court, that they were never put back on the schedule, which in fact they were, and confirmed multiple times. The court's denying the motion for summary disposition, and this will proceed forward.
There's other claims on there, Your Honor. Do we need to go through those?
No. But let me give you back your documents here.
Yeah, the plaintiff has a motion as well.
What's that?
I filed a motion regarding the request for the time to modify those.
I can't hear you, counsel.
Period.
This is the money.
Hopefully this is better.
This goes to this.
I thought, I don't know why I have a couple of things to keep this conversation. I filed a motion regarding the notice for the request that be deemed admitted. And I don't know if your honor has a copy that I can be mine.
Okay, let me just see here. There's a motion to withdraw admission or amend any matters deemed admitted. Did that motion, counsel?
Yes, your honor.
Okay. So motion to withdraw admission or amend any matters deemed admitted under MCR 2.312 D1A, or in the alternative to strike the request for admissions and all discovery untimely filed per MCR 2.301 B4 and exceeding the court scheduling order. All right. So let's take this bit by bit. So first, when was the discovery that you are indicating was untimely filed? When was that filed?
Your honor, scheduling order, I think it indicated a cutoff of November 17th. Then filed for discovery about 10 days before that, your honor. Which, as I pointed out in my motion, is untimely. The court rule says you have to file it not just before the expiration date of discovery. You have to file it within sufficient time that they can be responded to, and if need be, motions to compel be filed. So in this case, they should have been filed at least 30 to 40 days prior to that. And it's interesting to note that 2 days after they submitted the discovery, the motion for summary disposition that your honor just addressed was filed. So they proceeded with a SD motion before even addressing the discovery. And I'm asking your honor to strike that discovery for several reasons. One is the untimeliness under the court rules. The second is your honor's schedule order says that only one question for every $1,000 claimed in the civil suit can be asked of. They filed 2 sets of discovery. One was the interrogatories, which had 18 questions. And once I got the notice of admissions, I was not aware of it, as I indicated. I don't know what happened. Maybe I confused the two. I guess they both happened to have 18 interrogatories. But and interestingly, after what we just went through on also for some of this position, the very first question or request to admit is admit that the plaintiff and defendant had an agreement. Ms. Raval and Caltech had an agreement for this boiler repair. And we just went through all the various versions of what happened in transactions. But I'm asking your honor to allow me, if it's in fact really deemed admitted, that all 18 requests for admissions. I don't know if because there's interrogatories with each one. I don't know if those are tailored to the extent, or if not. But I think under the formal and under the circumstances, I'm just asking for time to respond to it and answer the 10 interrogatories that he's asking for. In terms of the first 10 interrogatories under the file interrogatories, not just the interrogatories that want to be requests to admit. We have 13 for the general interrogatories, 18 for the interrogatories that went with the request to admit. The affidavit that I filed in response to the moment for some disposition does cover all of the information in the first 10 interrogatories, all issues that were addressed for the first 10 interrogatories. Admittedly, I did not respond to the request to admit, and that's why, if your honor is so inclined, I'd like to do that now, or if well.
Okay, well,
I'm not sure what to do at this on that.
okay, well, unless I'm reading this incorrectly, your MCR that you cited is 2.423. 2.423. Is that what your motion states, counsel?
I'm sorry,
Being in custody? Is that
2.423D1A.
2.423. Okay, that's Michigan?
Yes, Your Honor.
Because the last one I'm showing is 2.421. We don't have a 2.423.
Michigan Court Rule? I'm sorry, I think I may have been referencing the federal.
Now, we have 2.301.
2.301, forgive me. Yeah.
That one, no, you have that one in there also. But you also have that you're moving pursuant to 2.423 D1A, but we don't have a 2.423. I looked in my book and I looked online in case the book didn't have the most up-to-date one. I don't have a 2.423. It ends at 2.421.
301D4. I don't have my Google.
Okay, well, I'm just telling you, counsel, the last one that we have in the 2.400 subchapter is 2.421, and then it jumps to 2.5. And 2.421 is regarding notice of bankruptcy proceedings. So maybe you're referencing the federal ones, I'm not sure.
Is there a 2.312D on it?
2.312?
Yes.
Yes.
I
2.312D.
D1A.
1A. Yes, there is effective admission.
Yes, I must have made a typo, but in my caption, Your Honor, I do reference or in the title, I do have MCR 2.312D1A. For whatever reason, that did not get correctly cited in the body. But some of the issues, Your Honor, I think should be litigated as opposed to because of a mere technicality. You know, I think the court rules and the general policy towards is to allow parties to litigate issues, not to have them be decided.
It is.
Things of this nature, and I'm asking for an opportunity to. Now, some things I'm going to admit, like the very first request to admit, yes, Ms. Raval did have an agreement with Caltech, as it states, and some of the other ones I don't recall. But as far as there being no delay or she got a refund, no, we wouldn't be here. You know, I'm not an unreasonable attorney asking for things that don't justify it, nor is she coming to me and asking for my assistance in this matter. You know, when she, as her affidavit states, has called 6 times, offered to come down, just as the text rebuffed Mr. Mendoza, Ms. Raval was also rebuffed and only told checks in the mail. Well, interestingly, it was never reissued. You know, if it was lost, if it was generated, I don't have a copy of anything. So again, all these things, Your Honor, we were just asking to allow you to have everything presented and decided by Your Honor rather than a deemed admission.
All right. And so you're asking for what's been deemed to be admitted to be withdrawn.
And withdrawn and to allow me time to answer. And to provide interrogatories if they wish, and that's fine.
Okay. And so, Mr. French, your response.
Your Honor, we just asked that we follow the court rule MCR 2.312B1, which states that if a party fails to timely respond or object, which was not done, the request for admission should be deemed admitted. And if they are admitted, then she's going to admit that there's no issue of fact. Yeah, that's our response.
You said 2.312B1?
Yes.
And when did you file your request for admission, Mr. French?
It was 10 days, I believe, before the discovery cutoff.
It was filed the same date as the interrogatories, but as a separate filing. And again, I must have, just going back in my own mind, I must have thought they were the same because by coincidence, there's 18 interrogatories that follow the request to admit, as well as 18 interrogatories in the submission or error anyways. So when I got that, as I noted in my motion, I called Your Honor's clerk and asked about the policy of the 10 questions because it's a $10,000 complaint. And she did verify, yes, that defendant only gets, well, either side only gets 10 questions according to the scheduling order. So I had to decide, well, what does that mean in terms of the 18 requests for admissions? So I thought I would just raise those issues here with my motion and allow me to start from scratch. So,
All right, so here's what I'm going to do. I'm not going to strike the request for admissions and all discovery untimely filed. What I'm going to do is I'm going to grant the request to withdraw the admissions and I will reopen discovery. So I will extend discovery 60 days from today. So that's May 6th.
thank you.
You're welcome. All right, so I presume an order is going to follow, one from Mr. Badari, one from Mr. French.
I'm sorry, did you say you needed an order from both of us?
Yes, one from Mr. French for denial of the motion for summary disposition, and one from Mr. Badari regarding the order I just stated regarding his motion for the admissions.
Thank you.
Okay, thank you. Have a good day.
Just clarification, the scheduling order limitation on 10
We will reissue the scheduling order. Did you all do any online dispute resolution? Or I'm sorry, any dispute resolution?
Not yet.
Okay, that was supposed to have been done back in November, should have been scheduled.
I'll wait till we get playing upon it and we'll get it scheduled.
If that is the one where there was something we did a phone conference, was that?
No, the phone conference is something separate. The court has a note on here, or in the scheduling order, there are dates by which dispute resolution, it says online dispute resolution. It can be in person, it doesn't have to be online. But by November 3rd of 2025, there should have been a date selected. It doesn't have to be the date of November 3rd. That's the date by which it has to be selected. So that needs to make sure that is being done.
Okay, thank you. Thank you.
Thank you. Have a good day. Okay, let's go off the record.
And we're going off the record, ladies and gentlemen. That's all she wrote. It's been a big week. We had a lot of stuff, especially on Monday. I hope you enjoyed. These were just some of the cutting room floor cases that didn't get shown for our daily, nightly case review that we do every single day of the week between 8 p.m. Central Time and 10 p.m. Central Time. Don't forget, tonight is the time change, ladies and gentlemen. For those of you out there who have to deal with time changes, I know there's some of us out there who don't have to deal with that type of stuff. Don't forget about it. So, yeah. That last case, we're going to be watching for the update on that last case because I found that one crazy interesting. I'm really happy Mr. Brandt is making moves forward and seems like he's got a pathway to maybe get things resolved. Hopefully things can improve for him in his life. And man, I hope that lady does not mess up in front of Judge West because she does not have any chances left. In the family, in the very first one, that are having all the disagreements for all the reasons, man, sometimes you just gotta put reasons aside. Say, sometimes it's just family. Just family, man. But I don't have to worry about that with my family because Mama Wolfie and Dada Wolfie are amazing and awesome people. So what can I say? I'm lucky as far as that. So we're done here for the week, ladies and gentlemen. I've got lots more to come out, but it's going to come out as individual videos through the course of the week and the week to come, and the weeks to come. Thank you so very much for tuning in. Go watch some Ryan Hall, y'all. If he's live, if he's on, be weather aware. And I'm your Lone Wolf Usul. I'm your humble host for these here videos, your curator at this channel, and I am out. Oh man, I don't want to forget, like I always do, to say a very special thank you to Zach, our great friend at Law Nerds Unite. Make sure you go over and check them out if you haven't. And Connie Sink, oh my gosh, thank you so much for your support today, and your super chats, all you crazy people, everybody who's been in chat today, everybody who's been lurking, all you wonderful, wonderful folks. Thank you so much for hanging out. Have wonderful luck, Marty. You're going to the casino. I hope you take the house. Take the house, man. I have but one thing to say, and that is our thoughts and prayers are genuinely with the people of Three Rivers, Michigan, the places that were hit by the tornado. Gosh, I hope you guys make a great recovery, and so horrible to hear about all that. But man, Ferris Bueller was still a good movie.